I and my colleagues at the firm Halad & Company have the challenge of arguing to advance keyteyahk legal rights and interests in Monya courts. And so during the presentation this morning, you'll hear a little bit about how we develop our perspective, what we hear and learn from our clients, and how we apply that within Canadian courts in litigation matters such as mentioned by Okamal Lewis, a constitutional challenge to the First Nations Financial Transparency Act, a matter that was dealt with in 2015 and ended with the Crown, that is the government of Canada, acknowledging that they weren't going to enforce any of the provisions of the First Nations Financial Transparency Act until such a time as they were able to adequately consult with those First Nations affected. Now, we also have other outstanding litigation, and I'll talk a little bit about that this morning as well. There is, of course, Onion Lake's constitutional challenge to Bill 1, now enacted as the Sovereignty Act, that's the Alberta Sovereignty Act. There is also a constitutional challenge to the other Bill 1, which was the Bill 1 from the previous Alberta legislature, which was the Critical Infrastructure and Defence Act, which some of you may be familiar with. That piece of legislation essentially allows the Lieutenant Governor and Council, for all practical purposes, that means the Premier's office, from designating anywhere within the province, that is the province of Alberta, as being critical infrastructure, including, of course, reserves, as well as traditional territories, as well as pretty much anything that the Premier's office so designates. So at instructions from Onion Lake's Council, we launched a constitutional challenge to that piece of legislation in 2020. And though that piece of legislation was enacted specifically as what I would call a knee-jerk response to the land defenders and other Indigenous protests that occurred earlier in that year, to date, not a single charge has been laid under that piece of legislation following Onion Lake's challenge. So today you'll hear a little bit about some of the work that we've done, but also some of the work that's been done by others and by other treaty nations. The title of my talk I chose to highlight what I perceive to be, from having a look at the agenda that was set, a major theme, and that is sovereignty in action. So taking action to reassert sovereignty of treaty nations, and doing so through a little bit of an exploration of two examples. And of course, though I was originally slated to talk about Bill 1 and the constitutional challenge, obviously I'll have comments on that as well too, and very happy to address any questions from anyone who is present here or on Zoom. If you do wish to ask your question in Cree, Vern Lewis has already volunteered, though he doesn't quite know it, to translate on the fly for me. So, the last time that I was invited to speak at a treaty gathering, it was a Treaty 6 gathering at Fort Pitt, or Waskakonse, and I did so in September for Treaty Days in 2020. Now, when I did that, I didn't have the benefit of a computer set up or a PowerPoint presentation. I was in a tent with others, and so I didn't do a fancy PowerPoint presentation for this talk, though I do have an agenda that I'm happy to circulate, just outlining some of the major points. When we advocate for First Nations, including Onion Lake Cree Nation, we approach the treaty in the classic legal definition of a treaty, which is an agreement as between sovereignties. So unlike a regular type of a contract, like things like a contribution agreement, for example, or some sort of an MOU or an agreement like an impact benefit as between a First Nation and industry, treaties by their very definition under international law are considered as agreements between sovereignties, and between sovereignties that have the full autonomy and full personhood under international law. So under that type of notion, under that type of principle of international law, these sovereignties are also co-equal. So there is a co-equality as between the Crown, and there is a co-equality as between every treaty nation that is adhered to those specific treaties. And that is the very fundamental premise with which we approach our advocacy for treaty nations. Now, you hear a lot of mention and a lot of response from the Crown saying, well, we recognize and affirm treaty rights. And that type of language is taken from a section of the Canadian Constitution called Section 35. But when you're sitting across the table and you're making these types of negotiations, or you're making these types of arguments, you hear a lot of the type of response saying, well, it's these treaty rights within the Constitution of Canada, that they're part of the Constitution of Canada or incorporated within the Constitution of Canada under Section 35. And our response is, well, no, they're not, because they were agreements as between co-sovereignties that predate Confederation, and indeed certainly predate Section 35, which was only enacted in 1982. And so that's the fundamental basis, the fundamental premise with which we construct the types of arguments that we make when we do this type of constitutional litigation. I'll talk a little bit about treaty promises and sovereignty. So again, the treaty not being a contract but an agreement between co-equal sovereigns, none of the sovereignty is given up through the process of treaty making. In fact, if sovereignty was given up in the process of treaty making, it stands to reason that it would no longer be a treaty. It would just simply be an agreement or some form of a delegation of authority. Now, this is an important case because the way that treaty promises were made, consider the promises, the undertakings, the representations made by treaty commissioners like Morris and Lier. They promised that First Nations way of life would continue as it was before treaty, meaning not merely that there was those same types of livelihoods that could be pursued, but the same jurisdiction over lands, the same inherent rights of self-government. And I know self-government is a bit of a dirty word, but consider it just as an inherent jurisdiction, if you will. And that inherent jurisdiction is maintained. So it's not merely a series of promises by the Crown that we're going to do this, that, and the other thing. And in exchange, we're also going to tell you how to govern yourselves and what to do for the next 150 years. None of that was contemplated within the treaty. It was contemplated that the First Nations sovereignty would remain unextinguished, and so thus the legal aspect of that sovereignty, what we as lawyers call jurisdiction, would continue. So I'll move on a little bit now to talk about rights and jurisdiction and some of the important differences between those. So again, at Waskakonse, I had the privilege of hearing from a number of elders as well as from Okamau Lewis speaking at that treaty gathering, and I was able to learn a little bit about some of the Nehewak interpretations and the ways in which treaty is kept by law keepers, by knowledge keepers, and by bundle keepers. And I was also instructed and told about sticks within the treaty bundle. Now, I mentioned at the outset, I am a Munya lawyer, and I go in and I try to argue Nehewak rights before Munya courts. So it's a bit of a sandwich, a bit of a challenge. And when I make these comments, I want everyone to be assured that it's not me saying, well, this is that and that is this. But as a consequence of what we have to do, we have to find ways of mapping on and considering how principles of Nehewak law and Nehewak ways of interpreting treaties, and this is Treaty 6 and 8 is most of the work that we've done thus far, and see how that maps onto Western notions of law so that we can properly argue them. And one of the ways that we consider it is rights, as being rights as sticks, but jurisdiction, that legal aspect of sovereignty, we consider to be the entire bundle. So if you have certain rights, certain sticks, if you will, those can be argued, and they have been argued discreetly as individual or standalone rights within Canadian courts. But what's happening more, what we're seeing an evolution towards, is an argument for actual jurisdiction being recognized before Canadian courts. And so we're moving from an interpretation where individual sticks may be recognized, for example, a right to hunt, a right to fish, a right to trap, a right to trade in the fruits of hunting, fishing, or trapping commercially, frankly, a right to set the standards and criteria for membership, a right to hire a lawyer. These are things that even within the last century only came about as a result of very concerted advocacy by First Nations, by the ancestors of people who are here today, who had the courage to go and actually argue these matters before the courts, as well as before parliaments, including Canadian Parliament, as well as the UK Parliament. Now, the recognition of treaty rights in Canadian and the UK courts is a topic that we could probably go on for several days, and I don't think you want to hear me talk for that long, or hear my voice even for that long, but it's important to appreciate as a lawyer. Most Western trained lawyers, if they talk and they learn about treaty rights and they learn about treaties, a lot of what they learn starts in 1982. And so we start with looking at cases like Sparrow, which was the first seminal case before the Supreme Court, arguing about what constitutes a treaty right and how to prove it, and the enormous, as it turns out, enormous effort it's required to amass the type of evidence and a full body of evidence in order to actually have those rights recognized, through to Haida and Mikisew. But the issue and the arc of how Canadian courts and UK courts have recognized treaty rights goes much, much further back. But a lot of Western trained lawyers don't have the benefit of reading through all of that history, much less the oral history that is in the other side of the scales when you're coming in and you are arguing things like rights and jurisdiction. For example, though the treaties were made as between co-sovereignties for many decades following, those promises and undertakings that were made in the treaties were treated as nothing more than just political promises. And in fact, there was a case that's called St. Catherine's Milling that went before the Privy Council. It was ultimately the highest level of court that could be argued within the British Empire at the time. And the issue is that those judges, they couldn't get around the notion that these treaties were as between sovereignties. And so these promises were made like any other promise made by the government of the day. It was a political promise. There was nothing within the Constitution that required the honor of the Crown to keep its promises at the time. But then you see a radical evolution that comes in, and again, it's not just because of the enactment of the Canadian Charter of Rights and Freedoms in 1982. It well precedes that. We have the efforts of Harold Cardinal in the 1970s, making his principled and powerful response to the white paper of the day. That's Trudeau the First's white paper, 69. And we see as well in other important cases like Badger and Calder talking about recognition of, even at that time, a potential title to lands, right? The fact that legal recognition that lands were unceded. And so all of these types of important cases predate what happened within the Charter. Then comes the Charter, then comes Sparrow, and then as well cases which I expect quite a few of you know about, Haida and Mikisew, talking about these new, what they style as Aboriginal rights. So again, there is a recognition that these treaties were made. There's a recognition that there are promises and undertakings in these treaties that needed to be kept. But they were coached and they were discussed in the language of rights. And so it was a promise made by the Crown that we, that is to say the Crown, the royal we, are giving to you, that is to say treaty nations, these particular rights. You can hunt, you can fish, you can govern yourselves pursuant to whatever amendments we make to the Indian Act at the time. And so, as you see, it's still a very imperfect and very incomplete type of recognition. And what we're working towards in our litigation, especially with the challenge to Bill 1, the so-called Sovereignty Act, is to move away as far as possible from a question of mere legal rights towards a question of jurisdiction, a recognition of jurisdiction that comes as a consequence in turn from recognizing the treaties as being made between co-sovereignties, unextinguished co-sovereignties. So there's a lot of theory, a lot of sort of high-minded legal thought that I'm trying to share with you, and of course not all of it is mine, but I've tried to summarize that as cleanly as I can. What are the practical consequences? Well, if you consider the duty to consult, which is a very, very much litigated duty all across Canada, not just in treaty areas, not just in treaty territories. The consultation spectrum that is set up by the Supreme Court, they talk about consultation being something as little as notice. So your consultation and lands offices, if you have one, might get a fax from such and such oil company saying, well, we're going to go do a seismic program here in this particular area, and that's all that they feel they need by way of consultation, and that's all that the government's consultation office in Alberta, the Alberta Consultation Office, for example, says is required. Just mere notice. So that's one end of the pole. And then at the other end of the pole is a standard that's been articulated by the United Nations, so it's an international law standard, and that is free, prior, and informed consent, which is also the usual standard for all types of agreements where somebody's legal personhood is unquestioned, right? You're an individual person with natural and inherent rights. Well, if I'm going to bind you with a contract or an agreement, I need to have your free, prior, and informed consent. But in between that is a huge gray area, and it's a gray area where lots of lawyers have gone to lots of courts and made lots of arguments. A lot of money has been made in that respect, but not a great deal of clarity. However, that's changing now. I'd like to share with you a brief example from Treaty 8. So this is Blueberry River First Nation, up in the northwestern area of British Columbia. This is a nation. Is there anyone from Blueberry here? Anyone? No. Well, hopefully nobody's ears are burning when I talk about this. But Blueberry River First Nation commenced a claim as against the British Columbia government. So this is the Crown and right of British Columbia, for what I would characterize as a death by 1,000 cuts of their treaty rights. That is to say, their use, their livelihood as derived, and indeed their cultural livelihoods as derived from their relationship with their traditional lands, being pockmarked and crossed and otherwise thoroughly eroded by the development of extractive resources. Now, not everything about extractive resources is bad. There's a lot of support here and there, and indeed there's a lot of initiatives. Some initiatives are entirely those of First Nations themselves. We recognize that. But this is what Blueberry River First Nation said. In their pleadings before the court, they argued that their treaty rights were being infringed as a result of 1,000 little infringements. So things that would have been closer on the spectrum of consultation towards the notice. And so they're getting a lot of little notices and a lot of little bits and pieces being taken. But cumulatively, the effect of all of those over time amounted to a major infringement, a derogation of their treaty rights, and of course a breach of the Crown's promises made by those treaty commissioners decades ago that your life would continue as it was before. And for the first time, they were successful. They were successful in arguing that the cumulative impact of all of these different types of resource development, all of these different types of dispositions from crown lands, that is, crown lands so-called, really they're traditional lands, legally recognized as crown lands. All of the dispositions that were made by the BC government were causing, again, cumulatively, a diminution and a derogation of their treaty rights. And they were successful in arguing that there could be death by 1,000 cuts. Now, what is the significance of that decision? Well, though the legal argument was made in terms of rights, individual sticks within the bundle, the outcome of that decision, following the court's decision, the government in British Columbia chose not to appeal that decision. Oftentimes, and people will know from any experience litigating treaty rights, that oftentimes, not always, but oftentimes, a crown tactic is to have matters delayed as long as possible. To require reams and volumes of evidence, to have court cases that go on into the decades. In this case, the British Columbia government decided they weren't going to take that path, and they chose not to appeal the decision. And instead, what they did is they developed and co-developed, if nobody considers that too dirty a word, with the British Columbia government, an agreement where, and again, this is an agreement, so it's not a delegation of authority. It's an agreement that's premised on treaty rights. That we're going to have not just merely a voice, but a measure of control, right? We're going to share jurisdiction with the Crown in respect of dispositions that are being made within our traditional lands. So that moves much closer towards a jurisdictional argument than a mere rights argument. So an example, some progress then from Treaty 8 territory, although similar efforts are being made also in Treaty 8 here in Alberta. Is there anyone from Duncan's First Nation here?
That's on the island.
Well, if they are, no one's admitting it, though. I see someone's in the front row is right from Duncan's, but I'm not going to single anybody yet. But there is a similar effort being made now, because though Treaty 8, as you all know, it goes beyond the boundaries of Alberta, and Blueberry in British Columbia is a Treaty 8 nation. In Alberta, there is a very different government with a very different approach towards resource development, and certainly a very different approach towards where things ought to be along the consultation spectrum. But Duncan's First Nation has commenced a statement of claim, arguing essentially along the same lines as Blueberry, but here in Alberta. And so those efforts are being made, those efforts are underway as we speak. So there's a positive example, and as anyone if you ever talk with anyone who's trained in law, you always get told to look at both sides of it, and on one hand this, and on the other hand that. So a counterexample that's already been discussed this morning a little bit, and that is the disposition of traditional lands. So disposition of traditional land is the way that we describe it, having regard to having regard to points 1 and 2 that we talked about, right? Those fundamental premises of what a treaty is and what a treaty means. If you read about it in the newspapers and the press release, or you talk to anyone from the Saskatchewan government, it's going to be styled as the sale of crown lands, or the sale of dispositions of crown lands. But in any event, it's a sale of interest, like an interest to use or extract or take something from those crown lands. It could be a harvest or pasture lease. It could be a right-of-way. It could be an SML, which is like a type of interest where you can do mineral exploration or for oil and gas exploration. But the long and short of it is, it's a sale of some form of interest within traditional lands. And each of those interests, in and of themselves, they may not amount to, again, this is under the government's consultation framework, they've developed and imposed, it may require nothing more than notice, but the cumulative effects of these types of land sales have a very real impact upon the traditional lives and livelihoods of members of First Nations that have those lands as their traditional territories. And so what we're seeing essentially is a move towards a jurisdictional framework within British Columbia, but a very clear move away from that type of framework and back towards minimizing the sticks in the bundle in both Alberta and Saskatchewan. And so you can see before you when you have your talk and you continue to talk and to conduct the rest of your meeting, you'll sort of see those two different poles, those two different directions that things could take. I'd like to summarize, because again, my initial purpose in being invited here to speak to you was to talk specifically about Bill 1, some of the effects of the litigation. So we've already talked about the effects of a little bit of past litigation that's been undertaken by others, Blueberry, as well as by Onion Lake, with respect to the challenge to the First Nations Financial Transparency Act and to the other Bill 1, the Critical Infrastructure and Defense Act. So what's going on presently? Well, there is now standing present a challenge to the Alberta Sovereignty Act. Now, this act was enacted just at the end of the legislative session, in fact, the very tail end of the legislative session, just before Christmas in Alberta. Nothing has actually been done with this act yet, so why challenge it? The reason why this act is being challenged is because of the way in which the act was made, the way in which it was introduced, the way in which it was debated and went through 3 readings of with the Alberta legislature, with not a mention, much less any meaningful consultation. Now, interestingly, the Alberta Act purports to have a recognition of Aboriginal rights. It specifically references, and it has a non-derogation clause. So it says, well, we're not going to be taking away your rights, and nothing in this act can be construed as being taken away any types of rights. But consider how that moves away from the original intent and spirit of treaty, how it moves away from a sovereignty and a jurisdictional framework towards a framework of mere rights that happen to be recognized and affirmed, and only under the Canadian Constitution, Section 35 of the Constitution Act 1982. You can see and you can read in that act how it limits, or how it builds a wall or insulation, if you will, around, and again, they call it Aboriginal rights, also as how it's styled under the Constitution Act of 1982. Now, they have even less than, that's even less than what the Saskatchewan Act has, because the Saskatchewan Act doesn't have any recognition of Aboriginal rights. There's no non-derogation clause within the Saskatchewan Act.
More redneck.
That one is styled the Saskatchewan First Act, and so they very obviously mean to put the Saskatchewan government first. The Saskatchewan Act is also a little bit more honest, but it's honest in the lawyerly sense that they actually talk about what it is that they're intending to do. They make specific reference to the natural resource transfer agreements. They make specific reference to the division of powers under the Canadian Constitution. That's the Constitution Act 1867. But of course, no reference to any of the treaties, and no reference to Aboriginal rights, even as defined or limited by Section 35. And so, what are the effects, the past effects of litigation? Well, the interesting thing about litigation is that it's but one part of overall advocacy, right? You can advocate within the courtroom, but of course, you can also advocate by coming together here, sharing each other's knowledge, and also too, you can advocate. Again, we've heard from our NDP MLA representative. I can't remember which riding it's from, though. I'm sorry.
Manitoba.
Saskatoon Centre. And again, that type of advocacy can be made before parliaments, before legislatures as well. So litigation is but one part of it. And the interesting thing about litigation is you don't even necessarily need to make your way into court in order to achieve your ends as well. So to cite as an example, one we've already talked about this morning, the First Nations Financial Transparency Act, the Crown went in on an application to try to enforce the act as against Onion Lake Cree Nation. So the carrot didn't work, so they tried to use the stick. They lost. It was an embarrassing loss. There was a change of government, and then lo and behold, without further litigation, without having to go back to court, there was agreement from the Crown that this is not the right way that we're going to be going about this. So we're backtracking. Same thing with the Critical Infrastructure Defense Act. In fact, we didn't even go to court on that. We filed it. They knew that there was a challenge outstanding to the act. But under Canadian case law, it's often the case that before you argue that your rights have been infringed, you have to show how they've been infringed. So, well, I got arrested just operating my trap line because the Lieutenant Governor and Council said that it was a piece of critical infrastructure. There were no charges laid under that act, so there is no way in which we can go in and say, well, because of the charges that were laid under this act, these rights have been infringed. Because they backed right off on that. Even at the Coutts border crossing, which you could consider as being as clear a day an example of blocking critical infrastructure, not a single charge was laid. And you know what they laid upon all the truckers that were blocking there? Criminal code charges or traffic safety act charges. They already had laws in place to deal with that. And that, of course, was the argument that they were going to have to face if they had decided to actually lay charges and let us go to court on these matters. So, in terms of present, what are we thinking about? What are we looking at in terms of the constitutional challenge to Bill 1? Well, we may not be in court before there's an election. And if there's an election and there's a change in government, there may be a change in outlook as well. So that's something that bears consideration within Onion Lake's own tactics and their own strategy in terms of this litigation. Of course, I'm counsel for Onion Lake. I can't tell you everything about what they're planning in terms of this, but there may be an important change coming within the next few months, and obviously that's going to impact the way that we approach this as.
Can I ask a question?
Sure.
In relation to both sovereignty acts of the province and Saskatchewan, which is more detrimental, the one that's acknowledging your rights will continue versus the one that goes back to 1867, because that's the file that we.
Well, it's one of those cases where by your acts you'll know them, right? So neither government has actually done anything with this particular piece of legislation. I can say that it's probably easier to actually challenge the Saskatchewan Act, because if you're going in and saying, well, there's a derogation of treaty rights, they can't point to any sort of non-derogation clause and say, well, no, there's not. Look, we have the non-derogation clause right there. Don't worry about it. It's fine, right? They don't have that option in the Saskatchewan bill, at least as it now stands. Now, importantly, the Saskatchewan bill, though, because it's not been enacted, it may still yet be amended. It's been referred to committee for study following second reading. I don't know whether or not those meetings have happened yet, but they ought to be happening probably within the coming weeks. And so hopefully the filing, and the public filing, and the press release, and the interest that's been generated by Onion Lake's constitutional challenge to Bill 1 in Alberta will at least resonate in at least parts of the Saskatchewan legislature. Well, one MLA at least is interested in it, right? So we'll hopefully hear from others too.
So just on the point, the position of both governments is not to work with First Nations, right? As Fort McKay versus Prosper says that the highest court in Alberta, that you can ask for the implementation plan. And obviously, you don't do that.
Yeah, and so really what you see is, and again, the treaty implementation plan, right? That is language, and again, it was Grand Chief. He was talking about the Prosper Petroleum and Fort McKay First Nations case. Here's a very similar example, right? It's something that if we had something of a different government in Alberta, you might get a result very close to what's more recently happened within the Blueberry case. Because the language that's being used in terms of a treaty implementation plan is much closer to the language of jurisdiction, right? And a recognition of sovereignty. So again, examples and counterexamples, right? And you'll see during your further deliberations that you have when you're here together for a few days, the different directions that things can take depending on your tactics and upon your strategy. So again, in terms of what does the future hold, well, in Saskatchewan, there is Bill 88 is before the Saskatchewan legislature. However, the types of infringements that were litigated in the Blueberry case, and indeed the types of infringements that were litigated in the Prosper case and many others, are still happening. They're still ongoing. There are sales of so-called crown lands within Saskatchewan, within Onion Lake Cree Nation's traditional territory, that are scheduled even this month, the end of this month. And so, again, it ought to invite further discussion as to what you as treaty nations are looking to do next. And then finally, just to briefly summarize some comments, a move from consultation to consent. You saw an example of that that was, I'll call a highlight or an important example from Treaty 8 in the Blueberry case, but smaller, more day-to-day examples of this type of thing happen all the time. One of the ways in which nations can move from consultation to consent is making agreements directly with industry proponents. And these types of agreements are things where, rather than going in and litigating, rather than dealing with the consultation office, the Crown office,
Excuse me.
individual nations are exercising their own jurisdiction and saying, well, if you want to come onto our traditional territories and do these things, these are what our expectations are, right? So that it's a taking of the initiative and crafting agreements that bring economic benefit and development to nations, and also to balance on the nation's own agenda pursuant to the nation's own membership. What membership tell leadership is, this is how we want to preserve our traditional rights, but this is also how we want to foster economic development. And you find a way to achieve that balance, and you do so not by way of just going around and around and around in circles with the consultation office, but by sitting down and making an actual agreement directly with free, prior, and informed consent with the people that you want to make agreements with, right? And so, by bits and pieces, there is an alternative to, instead of death by 1,000 cuts, there's also a possibility of building up brick by brick. And then finally, just to summarize the comments and bring us back to where we started from, talking about treaties and sovereignty, what we're seeing now, and one of the possibilities that you can plan, you can advocate for, and indeed one of the most important goals that we as legal counsel are working for Onion Lake Cree Nation, is to move from mere recognition of mere rights within the framework of Section 35 and moving towards a recognition of jurisdiction. The jurisdiction being a consequence of undivided, unextinguished sovereignties that were made years before the creation. They're about 30 years before the, well, in terms of Treaty 6, Treaty 8's, it's a few more years later, but even so, Treaty 6, almost 3 decades before the creation of Alberta and Saskatchewan, and Treaty 8, of course, a few years before the creation of both, but both predating the creation of the provinces. And in terms of Treaty 6, almost 60 years. In terms of Treaty 8, almost 30 years before the last major reconfiguration of jurisdiction under the Natural Resource Transfer Agreement, which, by the way, courts have actually recognized and said straight up that this would never pass constitutional muster today, right? But more than almost 60 years before that last major reconfiguration, and now almost 150 years later, we're seeing a reassertion of Crown sovereignty, that is to say, Alberta and Saskatchewan sovereignty, without recognition of the Crown's original treaty partners. And so that of course is a problem, and it's one that we as council are prepared to argue is a very obvious and a fatal flaw in that legislation. So that's our outline of the challenge to Bill 1, but it's set in a bit of a wider context so that people here can sort of hear and see and think about how that fits within a much more broader strategy in order to advance treaty rights and treaty sovereignty. So that is my presentation, although I'm certainly happy. I'm here to take any questions if people are interested. As well, if people would like to email me, I can make cards available. And Okama Lewis has already given me instructions that I'm to make every effort to assist people in understanding his nation's efforts, and so I'm happy to do that as well. Thank you.
Okay, we'll take some questions. I believe Chief Erminskin has a question or a comment. Go ahead, Chief.
Well, first of all, I want to ask you now, Rakio, I used to talk to me. Papate no tagawa ga taima. We got just got been no sits get dancing is mat sits gisto lam to the nagitogia. On Naskuma, Okama Lewis, Pascon Alga, na. I want to ask you if there's an opportunity for competition for intervener status, and also at the same time, if you're willing, I know we want to talk about unity and everything. I just truly want to commend them on their stance on protecting our inherent and treaty rights. But our lands that are just another challenge that they have, and I'm going to join them in Regina when they do go to the government and rally against the government for selling off Crown lands, which they don't have a right. And at the same time, because I met with Premier Danielle Smith a couple of weeks ago, and I got her mad because I said, we're having an NRTA conference in Muscatine coming up here in the early spring, and we want to invite you because we never gave you the resources. Boy, she just got mad. I think I set that tone, and so the rest of the meeting wasn't good for all of us. But I apologize to all the other chiefs. She was just mad. So she's, but if we can have, I know it's not in the courts, but if we could just sit down with the chief and other chiefs to talk about what's in your challenge, because I really want to acknowledge that, but at the same time encourage that we all come together and really work together to really fight against the governments. Hi.
Okama Lewis, you want to make a comment on that? Can you bring the mic over?
Oh.
And that's on intervener status and other support.
I appreciate that, Chief Erminskin. We all know that unity, and I still promote unity, especially in a big fight like this that includes the NRTA. The reason why I'm very careful and mindful of what I say, because Onion Lake will lead the charge, because we can capitalize on our location. Okay, we straddle the border, and we can capitalize on both. But intervener status is it would be, Michael, your legal opinion on how to best approach, without breaking the concept of unity. We need to try and keep building on unity.
So
because right now, things like letter writing is very important right now. If there is any Saskatchewan chiefs here, I encourage you, write to Saskatchewan government regarding the crown sales leases that are occurring on January 31st. Kasi pong gagito, but you know, let's work together on this. Kasi kita na unity represents strength. Thank you.
Hey, Lewis, thank you very much. Yeah, and Mike is gonna respond. Go ahead, Mike.
The best advice I can give just at the moment, and again, it is just at the moment, is to sit tight, keep an eye on what Onion Lake is doing with respect to its Bill 1 challenge. I just want to make an additional remark as well, that the rights argued by Onion Lake, though it's Onion Lake Cree Nation arguing treaty rights, the recognition of those rights is something that is going to be extended beyond just Onion Lake Cree Nation. So if there is a court decision that recognizes Onion Lake Cree Nation's rights as a Treaty 6 nation, then there will be recognition at law for the rights of all other Treaty 6 nations as well too. So that's one thing to consider. The other thing to consider is there are a lot of tactical and strategic calculations that need to be made in terms of intervener status. Usually an intervener is somebody who has a different set or an analogous set of rights that wants to argue. Now, if the rights in fact are the same rights as being argued for all Treaty 6 nations or on behalf of all Treaty 6 nations, then intervener status may make good sense in some cases, but it may not in other cases. So again, it's something that we as council are going to have discussions with Onion Lake Cree Nations. Okama Lewis and his council will need to get some instructions for that in the coming weeks, but definitely do stay tuned though, and stay interested in what we're doing, because again, Onion Lake is, as Okama Lewis said, in a very favorable position to lead the way by virtue of just the geographical location, straddling both the provinces of Saskatchewan and Alberta. But definitely stay tuned and keep an eye on things. Okay.
We have another question over here. Elder, go ahead.
Hello.
I'm not.
Okay. My name is White Buffalo Horn, Roger Prairie Chicken from the Blood Tribe. And then my question to you is basically, you know, the termination plans of our Indian rights have been from 69 White Paper, 1960 Buffalo Jump Paper, 1992 Failure of Canadian Constitutional Reform, and now 2019 the White Paper 2, which Trudeau government is creating a new relationship with Indigenous people, recognition of rights and tables. My question to you is, as an elder being taught that the treaties were holy pipe treaties, how straight the pipe stems is how straight we talk. And at the same time allowing the Europeans to coexist with us in this country of all First Nations across Canada. We are basically the landlords of the land. And when Harper went down to do you believe in the United Nations, he wanted to be a part of the United Nations. The United Nations told him no. Did you get two questions were given to him? One was,
Why ask you? You want to? He said no. You want to go?
one was, do you have all the lands conceded to, the Canadian government has taken all the lands yet? And the second question is, if not, have you given the trillions and trillions of dollars that you owe all First Nations across Canada? So by saying that, is our treaties entrenched without the gaming process of the courts? I'm aware of how the lawyers proceed and make the dollar. Simply telling you, you're a lawyer, is our treaties safe? Are they entrenched in our Constitution Act of Canada? Thank you.
Mike,
That's my question.
before you go, Mike, I just want to maybe remind the people on Zoom when you are listening, maybe mute your mics. Thank you.
So, in a word, not yet. Not yet. And you can sort of see where things have come since the St. Catherine's milling cases, where treaties were considered to be just merely a political promise. And you can trace the development of the so-called Indian policy through what was originally called the preceding act was called the Gradual Civilization Clause. So, frankly, and again, this is this type of lawyerly honesty. Back then, they were a little bit more honest about what they're trying to do, right? In 2019, they call it co-development of a new relationship, and back in the 1860s, they call it gradual civilization. But you can trace the arc of that development, and you can also trace it is a very slow, and it is a very incremental recognition within the courts. I don't think you could walk into a Canadian court tomorrow and say, and get a recognition that there are co-equal sovereignties between treaties, as between First Nations and as between the crowns. The reason why is that courts, they might be willing to say it, they might be interested in saying it, but there is a fear, and you can read the fear in between the lines of the judgments that comes out of saying that if we say that, it's going to fundamentally destabilize the Canadian state. And there's a lot of very interesting, very recent commentary on that. One of the professors with whom I'm working wrote a book on it. His name is Joshua Nichols. He wrote a book called Reconciliation Without Recollection. And it's something that I would definitely recommend to anyone who's really interested in tracing the full arc of recognition and how it came from a recognition where all of a sudden you get a terra nullius or a discovery type hypotheses, through to a recognition of, well, were political promises made, to a recognition that there's rights, there's some sticks, towards recognition that there may be a full bundle, there full jurisdiction, right? The type of recognition that you just asked about in your question. But no, to be very, very blunt, to be very honest, to talk straight, we're not there yet. But that's what we're working towards, right? Yeah.
Thank you. We have another question from Marie, small boy.
Dear woman is my spiritual name. Ginesegwa kape pakmuhti ano maya te pahmaltoni witaskuni hutskiano is witaskema kaapskod. And having traveled the treaty journey from my ancestral sense of being, and some how our ancestors walked this earth before the white man came, before the colonial came. Eko hau noch te kwetzimak kaapskod okakiaskis. This lawyer that speaks on supposedly, no offense, because you represent the colonial being.
None taken.
The colonial being came upon our sacred motherland and decided to dig roots into our sacred motherland. And there's no pun intended there, because they did not only dig roots, they did not try to plant themselves in our sacred motherland. They raped her. They take her lithium. They take her source of being, the life that she needs to sustain herself so we can live. And that constitution that you refer to the unwritten constitution that we have, that I know of, that I feel, that flows through every cell in my body, is a constitution that's not written. Because that constitution is written in here, in my heart, in my ancestors flow through me. And like, I'm going to sit here and listen and have someone tell me that I joined the Monial in his colonial way of being. No, I will not, because that's not who I am. It's not who I am. I am a part of you, but I am not you. We share what comes from our sacred motherland. But your Ota Mantunesigan, the thought processes that make you who you are, those aren't the thought processes that flow through here, because mine is connected to here. I have an issue with us. My question to you was, when did our being, our Niweo way of being, our ancestral way of being, consent to join the Canadian Federation? The Canadian Federation is a man-made constitutional law that says the rule of law rules all of our sacred motherland. It's based on the natural law and the spiritual law of the universe. That's what our Constitution is based on. And for a Monial to come and try and plant their roots on our sacred motherland, that can never be. And it's about peace. Peace, peace perpetuates love, it perpetuates respect, and it does not take life. The Constitution that Canada imposes upon the world is a white supremacist constitution. Because by taking 9124 and telling our people, we now govern you. Every sense of being that you have, we now take that over. We're going to show you through our education system how to be colonial. And we no doubt about it, we all have learned how to be colonial because of the system that's been imposed on us. And for us to we're trying to clean this colonial mess on our sacred motherland. And the lawyers that we use they don't have what we have up here or here to be able to go and defend us in a Monial court. They don't. How can you argue something you don't know? And for me, going forward, even the treaty, the number of treaties, 1 to 11, those are colonial labels. But what binds us in spirit are how our ancestors, when they prayed, and the Creator blessed the union of two human beings, two walks of life. One is based on the paramountcy, on the sanctity of all life. The other one is based on war, on adversarial approach to humanity. And that's where we as a people have our spirits are all connected. Not because of the number that the colonial being gave to us, Treaty 6. That's not me. Those are the terms that I can conceptualize in my brain and in my heart. Because Mama Wo means we're all spiritually connected. And the word that binds us is treaty. That's scary. Treaty, it's a colonial term, yes. But when you look across the land, I don't consider myself a citizen of Treaty 6, because that's a colonial term, it's a colonial definition, it's a colonial label, it's a colonial organization. I consider myself a treaty. And my treaty is not just Treaty 6, it's all of Turtle Island. All of Turtle Island. That's where my treaty rests. So the constitutional reform that you're seeking through the Western courts or the colonial courts, it doesn't do me any good because it doesn't protect our sacred motherland. Because you're just sitting there advocating, oh, we can, we can work around those, we can still dig in and take from our motherland. That's not us. That's not me. And I just want to thank you for listening, because since 1990, well, I've been working with the constitutional people way back in the 80s, and I've watched our leadership evolve. And we've not evolved to our way of being. We have evolved to be good white people, good monials. We have appropriated so much of the colonial way of being that we think like them. We think like them. So I just want to thank you for listening, but I want to ask you, when did our people join this monial government building that came to squat on our land? When? Hi.
Thank you, Mary. We have time for only one more question, okay? Because I hear a whole bunch of stomachs here. So, Chief, and we have also Chief Keeley on standby for his address.
So I guess I'll kind of do a preamble before I ask the question. So in the cases that are mentioned here, Blueberry versus BC, Fort McKay versus Alberta, and then there was another one, C6, Chief Roland Wilson. So the government and its courts works this way. If Chief Hukamau is the one with the lawsuit, and we are all interveners, when it is won, the government and the courts will just deal with Chief Hukamau's nation. All of us, it does not apply to all of us. Okay, that's how the courts rule. Unless all the nations in Alberta and Saskatchewan are a part of, or all filing, then it will apply to all of them if the ruling is won. If not, it's going to only apply to the nation. That's how the courts rule. So, in saying that, I think Michael, in his introduction, nailed what needs to be done. I guess the question was asked, well, when did we ask? When did we invite the colonizers to be a part of us? Well, that was what the treaties were for. The treaties was to share lands with the Inuit, the settlers coming in. But the answer, I believe, is in that the bundle and the sticks. Okay? So, if we operate as treaty territories, as a treaty bundle, then you can make your laws the sticks on how you're going to apply versus somebody ruling, right? A provincial, like you say, a colonizer ruling on your lands, your treaty rights, or your way of life. So this way, when your own laws are in place as a sovereign people, it limits Canada. Why? Because we didn't agree with Canada. We didn't have an agreement with Canada. It's with the king now. So can Canada say, hey, King, you don't have no authority here, right? And they have to give an account still. So the court's Chief Justice of Alberta has told us the only way you're gonna be able to counteract this stuff is when your laws are in place. So, you know, I think that's the answer on the bundle and the sticks. I believe that's how we go forward. So, our elders have always told us, not in their courts, right? Not in their courts. So, with that, that was just what I wanted to share, and again, in sharing in relation to the bundle and the sticks, Michael.
Thank you.
Would that, well, like the intervener status does not give that, right?
Well, the intervener status gives you a chance to make arguments before the court. But even the decisions that are made in cases where there are interveners, the actual decision, like the final judgment, only binds the individual parties. But even so, when you have that final judgment, right, and it talks about treaty rights and the recognition of treaty rights, that judgment is applicable to anyone who holds those specific rights.
Okay, so I guess the point I was gonna make was, what if all of the First Nations in Saskatchewan and in Alberta file that same suit that Chief Lewis is filing, instead of being interveners? So at the end of the day, it'll be applicable to all, at all nation levels and their territories. Thank you.
But you're making colonial law?
I believe Okama Lewis wanted to make a comment.
Ano humaganti. Kiwilma muy mamskutin. Maga ustopu kakskitami. Is kiksi kaitaskan gito oksinu. Kito no. Ka kiukau kuyuito titan. Kagismunno editi pikskunno. Igum kamamtanitamak. That way, I respect your comments, Elder, that way. Maga, going forward, there's somebody guiding us, the higher power. When you talk about the Constitution, I sat down with our lawyers, two of them, spent some time with them, gave them tobacco. I told them, Tansombe is Navak. I told them how Kiano is Navak. Our sovereignty, it comes from the higher power, natural laws. That's where I taught them. I tried to tell them that, and they understand where we're coming from. This is something I refrained, I have to say. I'm a lodge keeper in stuff. I'm a lodge keeper. And I've committed 4 years of Sundance, alluded to the fight that we're here, Chorus Kiano, treaty people. So Kaituan, Urmomi Mustofia. I thought I'd better mention that, and that our lawyers are aware of that. Thank you.
Okay, with that, we have to move on, and thank you all very much, and thank you very much, Michael, for an excellent presentation. And it's very heavy here because of all the sharing that's happening and things that we're hearing. And I told him I was kind of jealous of him. Where did you find these lawyers? I said, finally there's starting to be an understanding of what we're saying. And it's ceremonial, but I have to tell a lawyer joke. Just a few days ago, it was very, very cold in Edmonton. Michael, you're supposed to say how cold.
How cold?
I was on 101st and Jasper, and I seen some lawyers with their hands in their own pockets. Just kidding. Yes. So thank you very much, Michael, and you're gonna be around?
I expect so. I've got to clear out my room though. They told me that I'm overholding the room. I put down roots where I'm not supposed to, so I've got to get my stuff out of there.
Okay, so go ahead and maybe go ahead and approach him if you want to ask him more questions. But Chief Keeley has been on standby here from Treaty 11. So go ahead, Chief Antoine, go ahead.
Hi, thank you, Ron, and thank you, everybody in the room there. It looks like there's quite a bit of you there. I imagine that's what it looks like on the inside of a can of Click.
Yes.
You guys are so packed in there, but that's testament to the passion that we all have for our treaties. We were very honored to host the Treaty 1-11 gathering here in 2021, which coincidentally was the 100-year commemoration of making of the Treaty 11 here in Treaty Queen. And so, although there was a lot of issues with COVID and also forest fires that made it a little bit more challenging, I just want to thank Ron and his family and AJ for coming up and doing the ceremonies here in our community. It was very much needed, and really kind of realigned us and set us on a good path.
Center fire.
Right now here in our community, we're really facing some education issues. Our kids are really struggling in school, and a lot of kids are not going to school. And so, I've been really leaning on a few treaty specialists, as I call them, some of which are in the room there, to help us navigate that treaty right, which is a right to a quality education. It's very difficult up here in the Northwest Territories. Lack of capacity, lack of housing. It's the highest food prices and gas prices in Canada, and it makes it very difficult to get quality educators up here. That can really take a look at our way of life from our view. So just working towards enhancing the education for our kids is something that I'm really focused on lately. Also, last year at our Indian National Assembly, I was a part of a resolution that went against the adoption of UNDRIP. We've all been taught that UNDRIP is something that's coming to save us, and it's going to give us all of our rights. But UNDRIP didn't provide us with any rights. Our rights are inherent. They don't come from any state government. Our peace and friendship treaties, they're international instruments that are valid and they're legally binding by two sovereign nations. Our treaties have more authority than UNDRIP. And so it was a long discussion, a long debate, and ultimately we all saw the message, and we all voted unanimously in favor of directing our Dene National Chief to attend to these issues in the international arena, which is the United Nations. Canada is legally obligated to live up to various conventions and the agreements that it is party to. So we intend to hold them accountable there. We were not engaged properly in Canada's Act respecting the United Nations Declaration on the Rights of Indigenous Peoples. We are not against UNDRIP in its original intent that was put forth by all Indigenous peoples from all over
Original intent
all
of
over
our
this
treaty.
world, and but we do have issues with Article 46. It's a big problem for us because it clearly places the territorial integrity and political unity of the state as the only consideration. And so we had asked the question, what about Dene territorial integrity and political unity? That wasn't even a consideration. By rejecting this legislation, we're not saying we don't have rights. We are rejecting Canada's presumption that it has the right to legislate our sovereign rights.
Yeah.
And especially the presumption that our territory belongs to Canada.
Yeah.
So, you know, that was a very uncomfortable discussion for many, but like the elders of our past, we sat through it and we talked about it and we discussed it and we got direction from our elders and ultimately later on that evening that motion was passed. So you know, just looking forward to the discussion here at this gathering right now. I really wish I could have made it down, but it is quite the drive for me. I live way up in the north of 60, and but there are some of our members there in the room, and I rely heavily on the Treaty 1 to 11 group for advocating on behalf of these agreements that were made by our ancestors and our elders of the past. And yeah, just once again, just thank you for this moment to address you all. And I could see a lot of those stomachs grumbling through the video, so mine as well. I will pass this back to the co-chairs, and once again, Mr. Cho, take care.
Hi, thank you very much, Chief Antoine.